Here's the bad news. America's being held hostage by unelected dictatorial judges in black robes. And these judicial tyrants are driving the nation into a constitutional crisis, as noted just yesterday by Scott Jennings. Let's be clear. Because these orders infringe upon the core and plenary powers of the executive branch, and they are issued by mere trial judges of the inferior courts of the United States, these orders are constitutionally unlawful, and the judges issuing them are acting beyond their legal authority.
Judges do get to say whether the executive is complying with the law or not. That's been the case for decades, hundreds of years.
Well, I think there's a difference between saying whether you're complying with the law and then you have these individual district court judges setting effectively broad federal policy that is specifically reserved for the president of the United States. I think we do have a constitutional crisis, and it's being caused by these judges. They're not here to tell us. They're not here to tell us how to spend the money. They're not here to set broad federal policy. That is the president's job as elected by the people. These judges are supposed to be settling discrete, specific matters, not policy setting. I think Vance is right. I think Trump has a point. And these judges want nothing more to continue the lawfare against Trump.
But there's also good news. It doesn't have to be this way. Regaining our liberty is readily within our grasp. And in this video, I'll outline exactly what can be done. I am, of course, attorney Andrew Branca for the Law of Self-Defense. And if you like our content, then I'd like to ask you to hit those like and subscribe buttons and ring that bell, as it really helps us out. To begin with, let's start with a question of first principle. Could America, being held hostage by a few unelected trial judges, really be the intent of the Constitution our founders handed down to us? Is it at all feasible that the founders meant for the entire nation to be tyrannically ruled by a few trial judges claiming near limitless power to order every facet of government to do as they instruct? The very same founders who created our nation by securing victory in a desperate war against the most powerful tyrannical power then on the globe? The answer is hell no. The actions being taken by these tyrannical judges would strip America of any semblance of representative government, leaving us a tyranny run by judges and bureaucrats. I've read my U.S. Constitution pretty carefully, and I don't remember anything like that in it. And I'm not the only one to recognize this obvious political reality. Here's Elon Musk in the Oval Office with President Trump yesterday, speaking to the media.
If there's not a good feedback loop from the people to the government, and if you have rule of the bureaucrat, if the bureaucracy is in charge, and then what meaning does democracy actually have? If the people cannot vote and have their will be decided by their elected representatives in the form of the president and the Senate and the House, then we don't live in a democracy. We live in a bureaucracy. So it's incredibly important that we close that feedback loop, we fix that feedback loop, and that the public's elected representatives, the president, the House, and the Senate, decide what happens, as opposed to a large, unelected bureaucracy.
Hey folks, I want to take just a moment to invite you all to our upcoming live and 100% free Law of Self-Defense Hard to Convict webinar. This free webinar teaches you how to be hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property. The webinar is live streamed by me personally, and there's plenty of opportunity for Q&A. Best of all, it's 100% free, but we do limit seats to allow for adequate Q&A. So I urge you to grab your seat right now by signing up at lawofselfdefense.com/hard to convict. So where do we stand now? Well, the bureaucracy that seeks to rule us, having lost control of all elected levers of governmental authority, is now using lawfare. Tyrannical judges are issuing decrees at the rate of several a day. Just a few of the executive initiatives of President Trump that have been summarily stopped, usually with an ex parte temporary restraining order at which no member of the Trump administration was present to argue its side, include clarifying birthright citizenship, blocked, pause in federal spending during audits, blocked, offer of early retirement to federal employees, blocked, auditing of Treasury accounts by the Treasury Secretary, blocked, Closure of USAID, blocked. Reducing NIH grant payments to academic centers for overhead, blocked. Managing government-owned websites, blocked. Trump firing an administration lawyer hired by the previous administration, blocked, and he's ordered to use that hostile lawyer. And there are, of course, more, and more coming every week, pretty much every day. Keep in mind that Trump has so far been in office barely 3 weeks, and all of these judicial orders are blocking broad initiatives on which he campaigned and which fall squarely within the core and plenary powers of the president. Let's be clear. Because these orders infringe upon the core and plenary powers of the executive branch, and they are issued by mere trial judges of the inferior courts of the United States, these orders are constitutionally unlawful, and the judges issuing them are acting beyond their legal authority. So here's the two-step plan to address this judicial tyranny. Step 1, the executive branch declares correctly the orders an unconstitutional overreach by these inferior trial court judges and ignores them. Step 2, Congress, the legislative branch, both backs President Trump and holds these inferior court judges accountable for their unconstitutional overreach. Each of these judges, every one of them without exception, judges with a hunger for tyrannical power are ill-suited for their proper and limited role of settling disputes in a well-ordered society. Sound illegal or far-fetched? It's not. The Constitution itself empowers President Trump to end the judicial tyranny holding America hostage. And in a few moments, I'll also share with you how President Trump's just announced current strategy for dealing with these judges' lawless orders aligns with this plan. It's worth remembering that these tyrannical judges, with the audacity to frustrate the political will of the American people as expressed in the most recent election, are entirely subordinate under our Constitution, not just to the Supreme Court, but also to Congress, indeed, especially to Congress. In fact, the Constitution distinguishes these federal trial courts from the Supreme Court using the literal term inferior. Every federal court below the Supreme Court is properly understood to be an inferior court. And these inferior courts are not the creation of the Supreme Court. They are the creations of Congress. Congress brings the inferior courts into existence, and Congress can obliterate the inferior courts at its pleasure. And there's no role or authority for any judge outside a court. Let me say this again, because very few people seem to realize it. The inferior courts, meaning our federal court system, but for the Supreme Court, are created by Congress, the second branch of government, not by the Supreme Court, our third branch of government. If any of this sounds crazy to you, that's only because the people who control America's educational system have a vested interest in not educating our citizens on how our Constitution actually structures the governance of our nation. Maybe worth asking why they would do that. That the inferior courts, meaning all courts subordinate to the ultimate superior court, the Supreme Court, that the inferior courts are creations of Congress is laid out in plain text in the Constitution. Article 1 defines the role and authority of the legislative branch of Congress. And in Section 8, Powers of Congress, Clause 9 reads, quote, Congress has the power to constitute tribunals inferior to the Supreme Court, close quote. These are all the inferior courts of the United States, all the federal courts but for the Supreme Court. You may be wondering, but what about Article 3 of the Constitution that creates the judicial branch? Isn't the judicial branch a co-equal branch of government to the legislative, Article 1, and the executive, Article 2 branches? Well, it certainly is. But what does Article 3 actually create? Well, let's take a look. Article 3, Section 1 reads, quote, the judicial power of the United States shall be vested in one Supreme Court, close quote. But what about all the lower courts? Well, that same sentence continues. and in such inferior courts as that Congress may from time to time ordain and establish. More proof that all inferior courts subordinate to the Supreme Court are creations of Congress, not of the Supreme Court itself. So while the Supreme Court is a co-equal branch of government alongside the legislative branch and the executive branch, the inferior courts are not. They are inferior to the branches created by the Constitution. To put it another way, perhaps in a more obvious frame, the Supreme Court possesses authority as a co-equal branch of government that the mere inferior courts do not. And even in the context of the Supreme Court itself, literally the highest, the Supreme Court, that status as a co-equal branch of government still does not give it unlimited authority to order around the executive branch. Does anybody imagine that the president could tell the Supreme Court how to rule on a case? Of course not, because settling disputes is a core and plenary function of the judiciary outside the reach of the executive branch. Just as the administration of government is a core and plenary function of the executive branch and outside the reach of the judiciary. Indeed, any president who subordinated himself to lawless orders from the judicial branch would be failing in his constitutional duty under Article 2, Section 3 to, quote, take care that the laws be faithfully executed, close quote. And if the power of the Supreme Court to order about the executive branch within the scope of its core and plenary administrative powers is so limited as it must be in any constitutional order, then certainly the power of the inferior courts to order about the executive branch must be even more profoundly limited, if the inferior courts possess any such power at all. It may well be that some order delivered by the Supreme Court to the president may be valid, if, for example, the president were acting in a demonstrably unconstitutional manner. But even if so, it still does not follow that the inferior courts created by Congress have any such authority with respect to the executive branch at all. You may be wondering then, but surely the executive branch can't be completely above the law, standing by itself, completely independent of the judicial branch. There are three co-equal branches of government for a reason. Surely they all have a role in checking each other. Otherwise, why would we call our three-branch system a system of checks and balances? And you'd be exactly right. And that's precisely why there are three branches of government and not just two. Because the checking of any one branch of government in the exercise of its core and plenary power is not supposed to be at the sole discretion of any other single branch of government. Checking any one branch of government in the exercise of its core and plenary power is supposed to require the intervention of both of the other two branches of government. That is our founders' pragmatic political solution for an overreaching branch of government, that the other two branches would join together to check it. For example, imagine that the Supreme Court, notice I am not saying an inferior court, the Supreme Court, concludes that the president is acting in some demonstrably unconstitutional way. They issue an order to the president to stop doing that. Now what? Well, in a properly functioning constitutional America, the Congress would join with the Supreme Court by impeaching that president and voting him out of office, as could theoretically be done today if Trump were generally exceeding his authority as president of the executive branch within the constitutional power and duty to administer the government of the United States. What should be happening right now, today, is that the executive branch and the legislative branch of government should join forces to check the unlawful and tyrannical orders of these unelected, imperious, black-robed meddlers in an independent branch of government. And that's why I have a two-step plan for defeating judicial tyranny. One is the actions of the president, the executive branch, and the other is the actions of Congress. Step one, the executive branch correctly declares the orders of these inferior trial court judges an unconstitutional overreach and ignores them. Step two, the legislative branch both backs President Trump and holds these inferior court judges accountable for their unconstitutional overreach. Congress could today back President Trump and simply pass a law affirming Trump's authority as president and rejecting the power of the inferior court trial judges to constrain the core authority of the executive branch consistent with constitutional powers and limitations. For example, Congress could pass a law that says the actions taken by the president that are core to his duties are legally presumed to be lawful, unless the Supreme Court, and the Supreme Court alone, rules the conduct unconstitutional. This would certainly protect the executive branch from the volley of TROs currently being hurled by tyrannical inferior court judges to stymie the political will of the American people. Of course, such a law ought not actually be required, because any proper understanding of the Constitution itself already does this. But it would strip the inferior courts of the many federal statute pretexts they are using to issue lawless orders to the president. Congress should further seek to impeach and otherwise remove from the bench any inferior court judge who issues orders exceeding their authority. And under our constitutional order, these inferior court judges have no authority to interfere with the core and plenary powers of the executive branch. On similar grounds, Congress should remove from the bench each and every one of these tyrannical inferior court judges issuing orders exceeding their authority for having failed to abide by the Article 3, Section 1 conditions for employment as a federal judge, that they hold their offices during good behavior. I've already addressed this good behavior strategy for defending our Constitution in an earlier video. You may have seen that, but if you haven't, you can find it by clicking right here. Remember, it should hardly need to be said, but it appears it must. Not every order issued by a federal judge is necessarily a lawful order, and there is no legal or moral obligation to obey an unlawful order. If a federal judge summarily ordered you to burn down your home with your family inside, nobody would for a moment consider that a lawful order of that judge that they were legally or morally obliged to obey. We're not simply idiotic robots whom imperious judges get to order around on their whim. Judges, like all government officials in our constitutional order, have only limited authority. And the most quintessential limit to the scope of authority of any government official is the lack of authority to meddle in the core and plenary powers of an independent branch of government, which is precisely what these unelected, black-robed, tyrannical, inferior court trial judges are doing when they issue their imperious orders to the elected president of the executive branch of government. Another thought. Given the metastatic nature of the federal bureaucracy, the swamp, it also bears looking into whether any of these overreaching judges are issuing their orders in violation of the Code of Conduct for United States judges, which mandates that, quote, a judge must avoid all impropriety and appearance of impropriety, and a judge should perform the duties of the office impartially, close quote. One obvious form of violating these codes of conduct would be ruling on matters in which the outcome affects the judge's personal financial circumstances. And it turns out that more than a few of these judges have wives or adult children who are employed and receive financial compensation from various tentacles of the federal bureaucracy that President Trump is aggressively attempting to rein in. So President Trump's efforts are having a negative impact on these wives and adult children, and no reasonable person could expect a judge to remain impartial while his wife or adult kids were losing their jobs as a result of President Trump's policies. Yet these are precisely Trump's policies that these overreaching judges are ordering stopped. As just one example, consider Judge John Bates, who just issued a temporary restraining order against Trump policies this week. Judge Bates' wife, Carol Reese, is on the board of directors of the charity Hope for Children, which has for many years received funding from USAID, a government agency that Trump has just ordered dismantled and defunded. Keep in mind that Judge Bates could have simply recused himself from this matter and let a non-conflicted judge rule on the request for a TRO against Trump. But instead of doing that, Judge Bates chose to issue a temporary restraining order infringing on the core and plenary authorities of the President Trump executive branch even as President Trump's policies were threatening to have a negative impact on Judge Bates' own household finances. This obviously creates, at a minimum, a reasonable appearance of conflict of interest, an appearance of impropriety, a substantive doubt about the judge's ability to rule impartially, and therefore an explicit violation of the Code of Conduct for United States judges. Clear grounds for removal from the bench for failing to hold their office under good behavior as the Constitution requires. How many other of these overreaching judges has spouses or adult children who work and are financially rewarded by various governmental and non-governmental agencies that will be negatively impacted by President Trump's policies? Worth asking. The bottom line is this: President Trump, any president, is fully within his authority as the head of the executive branch to simply ignore the lawless orders of these judges, and indeed is constitutionally mandated to ignore such lawless orders. And Congress is fully within its authority as the head of the legislative branch and the creators of the inferior courts to clarify Trump's plenary power and then impeach these judges for the misdemeanor of issuing orders beyond their authority, or alternatively remove them for having failed to hold their offices during good behavior, all as allowed and required by the U.S. Constitution. Americans are under no obligation to live under the tyrannical rule of unelected judges who are patently exceeding their legal authority and issuing orders to their superiors in an independent branch of government. Meanwhile, these tyrannical judges issuing these lawless orders can, for now, sit in their chambers and contemplate the actual limits of their power and authority under our beautiful, fantastic, amazing constitutional structure. Now, having said that Trump has the legal authority and duty to refuse to obey lawless, overreaching orders from these inferior trial court judges, is Trump right now seeking to exercise this legal authority in defense of the constitutional sanctity of the Article II executive branch? The answer is no, for now. Yesterday in a press conference, President Trump indicated that he's inclined to patience in the hopes that the appellate courts of the judicial branch, also inferior courts under the Constitution, that the appellate courts will be the adults in the judicial room and check the tyrannical trial court underlings.
If a judge does block one of your policies, part of your agenda, will you abide by that ruling? Will you comply?
Well, I always abide by the courts, and then I'll have to appeal it. But then what he's done is he slowed down the momentum, and it gives crooked people more time to cover up the books. You know, if a person's crooked and they get caught, other people see that, and all of a sudden it becomes harder later on. So, yeah, the answer is I always abide by the courts, always abide by them, and will appeal. But appeals take a long time, and I would hope that a judge, if you go into a judge and you show him, here's a corrupt situation, we have a check to be sent, but we found it to be corrupt. Do you want us to send this corrupt check to a person, or do you want us not to give it and give it back to the taxpayer? I would hope a judge would say, don't send it, give it back to the taxpayer.
So Trump says explicitly he's going to defer to these overreaching temporary restraining orders, halting his policies, and hope that the appellate courts will do the right thing, the constitutionally right thing, although he notes that requiring these appeals has a substantial cost in both time and treasure. I'll also note in passing, after we just watched Trump say he would obey these overreaching court orders and appeal them in the usual course of litigation rather than ignore them, that the liars at CNN put to Chiron, Trump defends comments blasting federal judges on the bottom of the screen. However much you thought you hated the mainstream media, it's never enough. It never will be enough. But adequately hating the media, I'm afraid, is a topic for another day. Just as Trump is currently deferring to the courts, I too will currently defer to President Trump's judgment on this matter. But time runs out, Mr. President. The clock ticks fast. These orders from these overreaching judges are infringing your authority and are burning time, and may be the biggest act of political arson we've seen in our lifetime. If the appellate courts stop this trial judge tyranny in short order, fine. But if they don't, President Trump, I remind you that we elected you for a reason. And the reason wasn't to maintain the status quo. You have the legal authority and duty to disobey lawless orders. Should the time come, use it. For now, I'll close out by reminding all of you that if you carry a gun so you're hard to kill, that's why I carry a gun so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to know the law so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca at lawofselfdefense.com. Stay safe.